Law Simplified with Justice is anchored by Justice Maduforo. Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. We are well equipped in our litigation and advocacy for the benefit of our clients, corporates, and individuals. Why not visit us at 5 Oakfield House, Oakfield Road, Ilford, London, IG1 1EF. We are just 15 minutes from Liverpool Street Station. Tice Madox Solicitors. Try us. We are professional.
Hello, ladies and gentlemen, and welcome to Law Simplified with Justice. I remain your usual regular host, Justice Maduforo. Today on Law Simplified with Justice, I will be bringing and talking to you about a very important aspect which most of you have been emailing me and talking to me about. And because it's very crucial to the minority out there, not just the minority, but also to some of you also as spouses and relatives to those that are in the minority. Ladies and gentlemen, my name is Justice Maduforo, as I remain so, and the anchor and the presiding of this program, Law Simplified with Justice. I have discussed this program's topics in this program, diverse topics ranging from employment law to immigration law to criminal law to contract law to family law. I have discussed these areas with you, and the essence of this program is to kickstart your consciousness. Remember that, ladies and gentlemen. Therefore, on that note, whatever I say on this program, they are not legal advice, but you must first of all seek independent legal advice before you can act on whatever you hear me speak or any of my discussants on this program. Ladies and gentlemen, Law Simplified with Justice brings the best, as you know that. It's very exciting as well. I don't make it very boring. I make sure that you enjoy it, but at the same time learning at the same time. That's what it's supposed to be. But when you come to the office, we will take it further to take more detailed instructions from you and advise you accordingly. As you know, I'm a solicitor of the Senior Court of England and Wales. I'm also a barrister and solicitor of the Supreme Court of Nigeria. I am also a police station and magistrate court duty solicitor, accredited and licensed in England and Wales by the Ministry of Justice, administering free criminal police station advice at the police station at the initial stage under the legal aid agency. Ladies and gentlemen, moving from there, in introducing the topic today, which I want to discuss with you today, is very essential and crucial that whatever you hear me speak here, that you're making you and to enabling you and necessitating you to take action. Pass the telephone number on the screen to anybody you know that needs what I'm going to be discussing today. Pass the telephone number to them. Get them to watch the television today on Sky Channel 592. And ask them to also check us on YouTube. Ladies and gentlemen, today I'll be discussing immigration. And the topic today is immigration, insurmountable obstacles. Immigration, insurmountable obstacles. Ladies and gentlemen, over the course of applications, which are so dynamic and so flexible, in the recent time that we are in, as the United Kingdom race towards election in May, come in the next month, all the political parties, the manifestos, have continuously and continually surround this topic called immigration. As a matter of fact, on the table for all these political parties, a center stage is immigration. Control of immigration border, removal of illegal immigrants, removal of overstayers, to making sure that the United Kingdom is reduced. Obviously, even some extent of introducing quota system. And according to most of these political parties, it dominates part of the electorate's wish to ensure that immigration is reduced at the barest minimum. Whether or not that affects the economy positively or otherwise is yet to be seen in all the ramifications. Ladies and gentlemen, therefore immigration is very key as it takes center stage and continue to take a center stage in the lifespan of this country. As long as this country exists, with people coming in and going out, people coming to stay, and as long as that conflict exists around this United Kingdom in terms of other African continents and countries and continents, other countries, be it Africa, Asia, and America, and whatever disturbance is taking place, there are bound to be overflow in all part of the world. Overflow. That means immigration takes center stage. On that basis also, The immigration rules are changing. The government continuously lay before Parliament changes that will introduce into the immigration law to ensure that it's either easier for people to come in to stay or completely not easy at all for any of the immigrants to stay. Whether you are economic migrant or just an immigrant in whatever form or shape that you find yourself in the United Kingdom. The immigration rules of this country bind you. And as long as you're not a British citizen, even if you're a British citizen, either obtain your British citizenship through other means. It might be that once a serious offense is committed, this country has the power to strip you of that citizenship. Ladies and gentlemen, that is a different topic entirely. But today I'm discussing immigration, insurmountable obstacles. Now, where does this apply? Some of you continue to make an application to the Home Office to regularize your stay, either through your words or through yourself as a private individual, or through other arms or through other sectors that you find yourself as a student, as tourist, and as spouse, as parents, whatever circumstance or the level and the period you've stayed in this country, by various means, discretionary wise, any other means, asylum wise. You have so many applications, diverse applications out there. The question now will be that where does insurmountable obstacles apply? Now, to some of you especially who are applying through family route to stay in the United Kingdom, be it as a parent or be it as a spouse or for a person settled in the United Kingdom as either as an indefinite leave holder or as a British citizen. And you cannot miss this word, insurmountable obstacles, and especially your application is being done in the United Kingdom. And where contrary, it should have been done from your country of origin for you to gain entry clearance to come to the United Kingdom. But you have decided to make your application in the United Kingdom, either through these mediums I've put through to you, either through the discretionary levers, which is outside of the immigration rules, or within the rules, through the family route, the parents or spouse or whatever it is, and you've making these applications, especially those coming within the United Kingdom decisions. There are spouse applications that are made through the EU, which is European Union. I am not talking about that. This discussion goes beyond that topic, and definitely. So this discussion today centers on the domestic law, which is the United Kingdom controlled immigration rules. And in that respect, the application that you make to the Home Office have come back rebounded, refused. Now, from July 2012, there have been a whole sweeping changes of immigration rules. And I call it a tsunami of changes, because that was when the Home Office took steps to either import certain things that are outside of the rules and importing it into the immigration rules, which means now, rather than continuous exercise of discretion, the Home Office now sees it as a rule whereby you must meet the requirement of that rule. And once you meet the requirement of the rule, grant is essential. But as you all know, it's very difficult under the immigration rules to sometimes tick all the boxes. Well, because you don't tick these boxes, and because you can't physically, and one way or the other, it is difficult for you to return back to your country to make an entry clearance to come into the United Kingdom. Now, that is where this topic comes in. And that is where you raise insurmountable obstacles. Especially on Article 8 claims. Article 8 is Article 8 under the European Convention of Human Rights or Human Rights Act of 1998. As a matter of fact, once you raise immigration, once you raise Article 8 application and the rest of it, raise Article 8 issue in your application, you are bound to now consider whether you meet the rules. Once you don't meet the rules, the next stage you're discussing now is whether or not that the flexibility arm of the law can be extended to your application. By that I mean whether you were able to prove some other requirement that are required, that are essential for you to get the hand extended to your application positively, not negatively. And in that circumstance, you are looking at insurmountable obstacles. Now, what are insurmountable obstacles? Insurmountable obstacles are those obstacles that will prevent you, those obstacles that would essentially disproportionate disproportionate your application, or put the Home Office in decision disproportionately against you, considering your circumstance when you make the application to remain in the United Kingdom. So disproportion of your circumstance as against meeting the requirement is the definition, which means that if you make an application to stay in this country, you did not meet the requirement and you raise insurmountable obstacles. What are those insurmountable obstacles? What are they? Now, the list of insurmountable obstacles are inexhaustive. The list are inexhaustive because of the fact that what applies to A is not the same thing that applies to B. A might have issues regards to health challenges. B has issues with regard to the age. C has issues with regards to families. And D has issues with regards to other sectors, which is why I said that list is inexhaustive. As a result of that, what pertains of your application when you raise insurmountable obstacles? Now, ladies and gentlemen, insurmountable obstacles have been, because of the requirements in the immigration rules, raising insurmountable obstacles in the rules. Therefore, the government, therefore, the court has consistently been awash with the definition of insurmountable obstacles. So as a result of that, courts make the decision based on the merit of the case at the time before them. But however, that does not mean that there has not been plethora of cases and case laws of which these judges must follow, especially when there are similarities to the present application they are treating. So if the similarities have been dealt with by the upper court, which is the upper tribunal, or by a higher court, or by a court of appeal, or by European Convention of Human Rights, or even by the Supreme Court, their hands are tied, as a matter of fact, because they must make sure they consider an application in its entirety based on the case law, and the decision and the dictum of the judge is very essential. So meeting the requirement of insurmountable obstacles is essential. Most people that are in detention, most people's applications will be refused as a result of the fact that they are married to they're British citizens, or they have British children, but that is not enough. They have not gone further to show that there are insurmountable obstacles preventing them from returning to their country to seek entry clearance. Now, the purpose is that if you can meet the rules, then you grant. If you cannot meet the rules within this country, then what do? You return back to your country and make entry clearance to come in. Now, in the circumstance where you meet the rules to go to your country of origin, to clear to come in, why haven't you done so? The difficulty will be raising insurmountable obstacles. So these insurmountable obstacles that you will raise, what does it pertain? What does it translate to you? Ladies and gentlemen, I have been discussing insurmountable obstacles as regards to applications that are lodged in the United Kingdom to regularize a stay under the European Convention of Human Rights or Human Rights Act, whereby you raise Article 8 claim, or you raise Article 4 or Article 2 claim, whatsoever it is, as long as it does not take you to asylum claim, because most Article 2 or Article 3 claims will definitely push you towards asylum. But this discussion today is not taking into account asylum claims. They are outside of my discussion when I'm raising insurmountable and discussing insurmountable obstacles. Ladies and gentlemen, I will take a quick short break and I'll return back and will continue with immigration insurmountable obstacles. I remain Justice Maduforo, your preferred solicitor, on Tice Madox Solicitor, and on this channel, on this program, Law Simplified with Justice. Don't change the dial.
Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. Tice Madox Solicitors. Try us. We are professional.
Hello, ladies and gentlemen. I welcome you back to Law Simplified with Justice. As I was discussing before I took a short break, I introduced insurmountable obstacles in your applications. Now, when you lodge these applications and they are refused, and the question will be, normally the caseworker will raise that what the caseworker will summarize the circumstance by adding and by submitting that your circumstances have been taken into account. However, it does not raise sufficient insurmountable obstacles to warrant a grant. That is the catchphrase. But in that circumstance, what do? Now, this is where you need Tice Madox Solicitors. And I say this because you need Tice Madox Solicitors to harness your case properly, to take into account your circumstances and raise insurmountable obstacles in the way it should be raised. So a few think it's a DIY thing. It's not. Because it is different from when you meet an expert that understands the rules, understand the procedure, they understand the techniques, they understand how to dot the I's and cross the T's, they understand how to pray your case positively, to understand how to employ the case laws in your case, that understands how to use the dictums of learned judges in your case, they understand how to lift these cases in your circumstance, they understand how to perfect arguments and skeleton arguments and submissions on your behalf. That's why you need me, Justice Maduforo. That's why you need Tice Madox Solicitors. The telephone number is on the screen. They are on the screen. Give us a call, book an appointment to come to the office to see me in a relaxed mind, and I will take detailed instruction from you and advise you accordingly and run with your case quality, and I mean quality, ladies and gentlemen. Remember that when you come to see me in the office, you must pay consultation fee. Yes, you must pay consultation fee before I begin to discuss your case and take some time to analyze your case, table your case, and then give you quality advice that you will need. Quality advice you can run with. Quality advice you can depend on. Ladies and gentlemen, when I litigate, I also advocate for you, which means you have all total package in me. Total package in me. I litigate, I advise you, I litigate, and I advocate for you. And if the court refuses that, I take it off for permission for appeal. And guess what? None of my permissions for appeal fails because I am thorough. Because I have built a solid foundation to continue to run with your case. But guess what? I do not even want to get to that stage. The first stage I want to get to is application, lodge, application succeeded. Okay, an application succeeds. And when you succeed in that circumstance, you are happy. I am happy. The firm is happy because we put a smile on your face. But in any event, that fails in the first stage because the caseworker has been negligent of his duties to consider your circumstances, which we have raised, I have detailed, then that is a good field day for me in court. Or if you don't have no right of appeal, it's a good field day for me when I lodge a judicial review application for you. Ladies and gentlemen, I remain Justice Maduforo. I cannot overflog my quality because it's all there for you. The testimony abound in terms of those who've come to Tice Madox Solicitors, sought advice, and instructed me to run with their case. They have put a smile on their faces and they know the difference between when a professional handles your matter than when a quack handles your matter, or those who parade themselves as representatives. Now, Tice Madox Solicitors are exceptional. We take time to deal with your matter, send you client care letters, write to you, confirm what we are doing for you, keep you in the know all the time, in the know. Once we receive a letter from the Home Office, we do not waste a minute. You are communicated immediately. And that is my standard instruction in Tice Madox Solicitors. None of the staff that work in Tice Madox Solicitors will ever sit on a letter that comes from the Home Office or from any other third parties or any other party we are dealing against or for, and without communicating that with immediate effect. Letters are sent out to you without delay, ladies and gentlemen. So you are dealing with the best firm that has imbibed with the best practice. Client care letter is quality. That's all you need. We advise you accordingly as we run with your case. Insurmountable obstacles are essential. There are case laws where courts consistently interpreted what amounts to insurmountable obstacles in your circumstance. When applications are made, even when you think you don't merit the application, run to Tice Madox Solicitors. When you sit with me and I discuss with your case, I'll be able to tell you where the insurmountable obstacles comes in, where I can draw life from your circumstance and run and lodge the application once you have given me the instruction and go ahead to do so. Ladies and gentlemen, we'll guide you along the line as we go along the line dealing with your matter. Insurmountable obstacles. Now, what are they? There are certain times when you have received a Section 10 appeal or Section 10 decision from the Home Office removing you to your country of origin on the basis that decision made to remove you. Once that decision, we call a Section 10 decision, has been made, and which you were not entitled to appeal, by the way, and then you got that right of appeal. It's called Section 10 appeal. And once you receive that appeal, this is a specialist appeal. It is not the normal appeal you tick box and do paper hearing. Don't do that. If you get that decision, run to Tice Madox Solicitors. Don't do that. Don't tick paper hearing. You would need oral hearing in this. Come to Tice Madox Solicitors. If you think your circumstances are precarious, don't worry. When you come to Tice Madox Solicitors, we want to be able to advise you as we get along, because we've dealt with these every single day. And every single day I'm in court dealing with matters of Section 10, decisions to remove people from the United Kingdom, bail applications that are completely useless, that even the client themselves have lost hope. When they speak to me, and when they engage Tice Madox Solicitors, they know that success is already even in their palms. But because they were completely ignorant of the fact, unless and until they came to Tice Madox Solicitors, a smile now broadened their face. Ladies and gentlemen, what am I talking about? You received that Section 10 appeal. Do not sit tight. Come to Tice Madox. We are specialists in dealing with Section 10 appeals. We will package Section 10 appeals. When I come to court to advocate for you and prepare your witness statements, fortify your skeleton argument and grounds of appeal, you will know definitely and for sure that you have taken the right decision. Now, insurmountable obstacles will be infused into that Section 10 decision or an appeal. And if you have not received that, and you, for instance, you're making an application, the Home Office have rejected the application on the basis that the circumstances does not warrant and does not constitute insurmountable obstacles, or that you made an application as a parent, or as a father, or mother, or partner, you've made an application as whatever circumstance you made, or discretionary leave even outside of the rules. You've made Section Article 3 applications on the basis of your health, and they've all been refused. And you've made applications in whatsoever category you've made it, and they have reasoned the fact that you did not fulfill the immigration requirements, and especially those on the EX1 or FM, Appendix FM category, or those that you didn't meet the suitability, eligibility, and rest of them. And they have summed up and concluded that your circumstances does not warrant any insurmountable obstacles for a grant of leave to remain, limited or otherwise. Ladies and gentlemen, that is where you need Tice Madox Solicitors. Okay, that's where you need Tice Madox Solicitors. I've dealt with cases where the judges have stood up, and even when they are sure that this case is for refusal, but when I begin to address them and submit with case laws, with dictums of the court, they would certainly know that clearly their hands are tied. Clearly, that is a case for them to consider. That clearly, even on the face of it, prima facie, that case is gone. But when I begin to address the judge, through admissible and persuasive submissions and case laws and dictums, these judges will at least consider the decision which they need to make twice before pronouncing that or putting that on paper. Let me tell you, some judges read this document. When they come into the courtroom, their decision is already to refuse. Yes, because remember that they have already read their document before they come into court. Some of them that are sharp enough, or who are not lazy enough, they read it with all due respect and haven't read that. And some of them have seen that there's no more case here, and they have predetermined to refuse the appeal. But the mistake they make will be making such decisions and appear before them. Once I appear before them, because they want to be carried along too. They are smart judges. They know those who are smart enough presenting persuasive argument before them. They know that. And when I stand before them to begin to address them and to submit on behalf of my clients, clearly they have no option but to consider there is a potential in this case to grant. No matter how useless you think your case is. Wait until I say so. Wait until I tell you so. Or because I have taken time to take instructions from you. Instruction from you, detailed instruction from you. When I mean detail, is underlined, emphasis on detailed, and then be able to advise you what to do. And when I raise insurmountable obstacles, I will guide it, build it, nourish it, and also present it in a way that it should be. Most of you that do these applications yourself, you know clearly. Some of you don't even have cover letters. Some of the representative you use, I call them fine enclosed, representative, because they just can't even make any simple argument. And then they complete an application form and then fine enclosed form. No, I don't do that. You come to a firm that takes time to research, takes time to bring in relevant, recent, and relevant materials, and use it to argue for you. Why wouldn't you want that? Why wouldn't you want that? Run to Tice Madox Solicitors. Pass the telephone number to whoever that needs this advice, and let them come to see me in the office. The address is on the screen. As I told you before, There are so many case laws that deals with this. We have the MG assessing interference with private life. This is a Serbia and Montenegro decision, 2005. This is an upper tribunal decision. And we also have Nyanzis against the United Kingdom decision of the European Court of Human Rights decision. We also have Iswazo decisions as well. This Article 8 under the new rules decision is 2013 decision. We have also Green against Article 8, Green and Article 8 new rules as well decision that had to deal with the 2013 decision also, all dealing with matters of the Article 8, ladies and gentlemen, which is what I'm talking about, which mostly kickstarts insurmountable obstacles. They are matters that kickstart insurmountable obstacles. And also the case of Niagara. Niagara is a very powerful case, although that decision did not go well in the favor of the appellant. But, however, the judge's solid decision and solid comment has been the breaker of any application that has come before the Home Office. There are some decisions of the courts, of the upper courts of record, that are not in your favor. But because I take time to read these judgments, some of these judgments ranges from 80 paragraphs, 200 paragraphs, and many more. But I take time to read each and every one of them, interpret them, and lift up such comments that will assist you. The decisions, the fact that it did not go in the favor of the applicant or the appellant, as the case may be, does not mean that it would not favor you. But because read in between the lines, because I have the eagle eye, the macroscopic eye, to lift up these cases, these dictums that are in your favor, ladies and gentlemen, you cannot overemphasize that. The Niagara case is a very bullet point, which I normally use as well. And especially it relates your case. You have the case of a Gulshan matter is also a solid bullet point in Article 8 application that relates to insurmountable obstacles. The correct approach to take in respect to that. Judges have made decisions, Nashim and others decisions, and this is a matter of the upper tribunal as well. It's a 2014 decision. Can you imagine? It's a new recent decision which the Court of Appeal, which the upper tribunal has also produced a guideline. As I said to you earlier, your circumstance differs from the other. So therefore, that is why the list is inexhaustive as to what will amount to insurmountable obstacles, the right approach to take, the correct step to take when assessing that circumstance, because they are individualistic in nature. And that's why when you come to Tice Madox Solicitors, I take time to unravel your own peculiar circumstance, and I run with it and fine-tune it and present it persuasive, guiding it and supporting it with case laws that will enable the decision on the caseworker to run with it. And I'll pray for the discretion of the caseworker. If the caseworker refuses, I will use the fact if you do not have right of appeal, I will use the fact that the Home Office was unreasonable in his decision. And then we proceed to the judicial review, upper tribunal, to apply for judicial review. Ladies and gentlemen, this is what time can permit me. I wish I could go on and 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 on, but I can't. But I wish to see you. Next time you call and book an appointment to see me in the office, I will take the matter further and advise you accordingly. Ladies and gentlemen, thank you so much for watching. Your time has come.
Tice Madox Solicitors is results-oriented, but with a distinctive approach tailored to our clients' needs in our specialist fields: immigration law, criminal law, employment law, commercial law, family law, and contracts law. Tice Madox Solicitors. Try us. We are professional.